Kalispera Saz. My name is Lucy Loizou and welcome to this week's Family Law Show. I'm joined in the studio by a special guest, and this week we'll be talking about the child support maintenance system in this country. Over the forthcoming weeks we're going to be covering a number of other topics to include divorce, finances on divorce, children work, if your relationship has broken down and you want to move to another jurisdiction, what happens then? If you're unfortunate enough to be in the court process, how can you best deal with that? And also importantly, looking at ways of resolving family disputes without having to go to court. The format of our show is it's questions and answers, and each week I'm joined in the studio by a family law specialist who will give guidance. So before we move on to today's show, I'm going to introduce and give a little bit of information about my firm and also some info about my background. This programme is brought to you by the International Family Law Group. We're a niche family law firm based in Covent Garden. We provide family law services to both national and international clients, and we often deal with cases that have an international element. In terms of my background, I'm a family law solicitor and I've been practicing family law for a number of years. I'm of Greek Cypriot origin and speak Greek fluently. I deal with both financial cases and those that concern children. Some of you may know me from my work on London Greek Radio. For the last couple of years, I have had a phone-in show where our listeners call in fortnightly to ask questions about family law. We're there to help the community. I also write regularly for the Barigiagi newspaper, as well as other family law websites. So moving on to today's show. So we're joined in the studio today by my colleague Katie Harris. Katie is a trainee solicitor at the International Family Law Group, and she deals with finance and children work. She often attends court and sometimes does her own advocacy at court as well. Katie, welcome to the studio.
Thank you.
So Katie and I are going to be discussing the current child support system that is in place in this country, as well as looking at some of the future changes. So first of all, Katie, tell us a little bit about the current child support system.
Well, the current child support system is administered by the Child Support Agency, which is also known as the CSA. And the CSA was meant to deal almost exclusively with child maintenance. The problem was that from the outset it was beset with problems, and CMEC was therefore then established, which assumed responsibility for the CSA. And for these reasons, the names are often used interchangeably. So when one person says CMEC, they sometimes mean CSA and vice versa. And the CSA will actually continue to administer the child support system on behalf of CMEC until the 2012 scheme comes into play, at which point the CSA will actually be disbanded.
And we'll be telling our viewers a little bit about the new child support rules a little bit later in our programme. But sticking to the current CSA scheme, when does it apply?
Well, the current scheme applies most of the time, actually. CMEC has almost exclusive jurisdiction. The legislation provides that parents of a qualifying child are responsible for maintaining that child and paying support for them. And a qualifying child is defined as being unmarried and under 16 years old, or under 19 years old and receiving full-time education. And to be qualifying, in fact, the child, at least one of their parents, must be a non-resident person.
Right.
And the definition of parents within the legislation includes married and unmarried parents as well.
Right.
The definition doesn't actually extend to step-parents. So as you can see, the legislation is quite difficult to understand, and
Sure.
a lot of definitions that you have to fulfill.
And the Child Support Agency and the website, they do have some helpful guidance sections, so have a look at that, but also take legal advice from people like Katie and I who can advise you about the system. And looking at some of the definitions, you talked about the non-resident parent, and there's a concept called parent with care. Just tell us a little bit about what those terms mean.
Right, well, the non-resident parent is the parent that doesn't actually live with the child but has responsibility to maintain that child. And the person with care is the parent that actually lives with the child and looks after the child day to day.
Okay, and so there's those, and usually it's the person, the non-resident parent, that pays the maintenance.
That's right, yeah, usually, yeah.
Okay. And so if the old scheme does apply, well, I should say the current scheme, because the new scheme hasn't quite come into play, how is child maintenance calculated?
Right, well, the rate actually depends on the non-resident parent and their weekly net income. So, for example, and also the amount of children that they actually have. For example, if they're earning £200 net per week, then the legislation says that the amount they have to pay is dependent upon how many children they have and also the basic rate. So the basic rate for one child is 15% of their net weekly salary. 2 children is 20%, and 3 or more children is 25%.
And what you will find is that whenever you're speaking to a solicitor or seeking advice, whenever you're putting forward proposals for what maintenance, you know, a father, usually it's the father, will pay to the mother for the children, these are the types of percentages that we use in negotiations. One thing that, you know, Katie and I would say is that if you can obtain a higher maintenance settlement, either by negotiating it via consent, than going to the CSA, it's better to do it that way, because if a negotiated settlement above these percentages obviously is better for the person. One point I think that's important for viewers to be aware of is, let's say that you do come to an agreement with your spouse that he or she is going to pay a specific amount of maintenance per month, and that is embodied in a court document that says husband pays X by way of child maintenance. That order will stay in force, you know, continuously, but 1 year after the date of that order, either parent can then go to CMAC or the CSA and ask for an assessment on child maintenance. So potentially you can have a period where you're receiving a higher level of maintenance if you can agree that, but remember, after a year from any court order, either parent can go to the CSA. So looking at the CSA scheme, we've talked about when it does apply and what you have to do to qualify. When does it not come into play, and what happens then?
Okay, there are a number of times when it won't actually apply. One, for example, will be when either the qualifying child, the parent with care, or the non-resident parent are not resident within the UK. Right. So barring a few exceptions, CMEC and CSA won't have jurisdiction to deal with that issue. And also, it won't be able to deal with stepchildren. If they are children of the family, per a different set of legislation, then you can instead apply to the court for a court order for maintenance instead. CSA won't apply if the child's too old. For example, if they're above the 19 years old or not in full-time education any longer. And also, crucially, it won't apply if a parent's net income is above £2,000 per week. So you'd have to, in that situation, have to apply to the court for supplementary maintenance. So
it would be like a top-up?
Yeah, that's exactly right, yeah.
And one thing just for viewers to be aware of is if you are in that bracket, so your spouse or, you know, parent, for example, is a high earner and they earn over £104,000 net per annum or £2,000 net per week, before you can ask the court to give a top-up on that, you have to get a maximum assessment from the CSA showing that a maximum assessment has been made, and it's only with that confirmation that you can then show a court that actually you want more than the maintenance that the CSA can order. So what can the court do, and when can the court become involved?
Right, well, the court can become involved when the CSA doesn't have jurisdiction to deal with the issue. So, as we just said, when you have step-parents or children too old, or perhaps they're not resident within the UK. And they can also become involved when there's supplementary maintenance. So, for example, as you just said, the income's above £2,000 per week net. And also for additional educational expenses, for example, maybe the cost of school fees. And another situation is when the child has disabilities. You may want further top-up, you know, to deal with further expenses that the calculation may not cover.
And if the court does become involved, how will it determine what child maintenance should be paid?
Well, the first consideration is always going to be the welfare of the child. And it will also consider other factors within another piece of legislation called the Matrimonial Causes Act, which is made in 1973. For example, if you have the step parents and they have a natural father, the court may decide that the natural father ought to have the responsibility of paying for their child, therefore perhaps may order the step parent not to pay as much. And in practice, I mean, the court usually use the CSA calculation figure as a starting point, a good reference point.
So those percentages of 15, 20, 25%?
At the moment, yes. As we did mention, there's a new scheme which is coming into play, so those percentages will change. But at the moment, that's the basic rate, yes.
Yeah. And one thing for our viewers to be aware of, Katie's been talking about the Matrimonial Causes Act 1973. That's a piece of legislation that applies usually between married couples. But similarly, if you're unmarried and you seek maintenance from the court because the CSA doesn't have jurisdiction, you can still apply for provision for a child, and that's under a separate piece of legislation. And we'll be covering that in a separate programme. So Katie, we said at the start that this is the current CSA system and changes are coming into force in the next year or so. Yeah. So let's talk a little bit about that new scheme. Okay. What is the new scheme?
Well, the government are actually currently winding up the CSA 1993 and 2003 regimes.
So the current scheme?
That's being wound up, and they're replacing it with the Child Maintenance Service. So that's the 2012 scheme. And the whole point of this service is designed to encourage parents to come to their own agreements in relation to child maintenance.
And, will the new scheme extend the current rules?
Yes, it will do so, yeah. The definition of child is going to be increased, so it's going to include children of 20 years old and in full-time education, whereas previously it was 19 years old. And various enforcement options are being added. For example, the court may now have power to take away a person's passport or give an offence of failure to notify a change of address as well for the non-resident parent.
Okay. And what will be the options for payment or under the new scheme?
There's a couple of options. The first is the usual method, which would be direct payment, and that's direct payment directly from the bank account of the non-resident parent to the parent with care, and there'll be no fee for that service. Okay. There is also going to be an alternative collection service for those who need help with enforcing collection.
Okay, so two different methods of collection there.
Yeah.
I mean, it sounds as though that the CSA is going to now have quite more extensive powers, certainly in terms of enforcement. And one thing I would say to our viewers is that is quite an important thing. With enforcement, it's a very complex issue, and it's good that the CSA has so many powers because it avoids you having to go to a solicitor and then go to court in order to, to enforce the order, any maintenance. So that's important. So will there be any changes to the calculation of child support?
Yes, there will actually be a few. The first major one will be that it's going to be based on gross income, no longer net income. Okay. And this information will be coming from the HMRC, so it'll be very accurate. And the percentages have also increased, which is largely to reflect the fact that it's a change from net to gross. But it does, in fact, in many situations that we've calculated a few examples, it does result in a higher liability of maintenance being calculated in various situations compared to the previous schemes. I mean, I think I would say to our viewers, and I'm sure Katie will agree, is that if you are currently in the process of getting a divorce or you're not married and you're trying to arrange the child support arrangements for your children, ensure that you obtain legal advice, not just on the current scheme that's in play, but also on this new scheme that we're talking about, because really you should be focusing your negotiations and discussions as to what's going to be happening in the future. So when will the new scheme apply then? Well, actually they're beginning to open new cases now. So the end of 2012 was when the new scheme was kicking in, really. They're starting with the pilot group of 4 children families with the same father, and this will roll out towards other families during 2013 with the hope that all existing cases will actually be closed by 2017. It'll be interesting to see how that works in practice. Yeah. Most of our clients come in and they have various experiences with the CSA, shall we say, and there can unfortunately be, delays, but we'll see. Hopefully it's going to be better
for families. So we've talked about these new changes that some have come into play already, some are coming into play. How will this affect the individual?
Well, once the changes have been made, their case will be closed.
Right.
And
so the current case?
The current case will be closed. They'll have to make a fresh application underneath the new scheme. And there's no need to worry too much because any arrears accumulated under the old scheme will remain outstanding and due unless and until the parent with care, so the person that's receiving the money, decides to forgo the arrears.
That's good, and that's very helpful because sometimes the arrears can be quite substantial. And what are the options for a parent who wants to secure child support for their children, apart from necessarily going to the scheme itself, to the CSA?
Well, the principle of the new scheme is that it's all about encouraging parents to make their own agreements and arrangements. So, for example, agreements can be in writing, and parents may want to avoid the involvement of the agency and the courts altogether. So they could opt for a simple maintenance agreement, which is sort of like a binding contract, or even have their agreement embodied into a consent order. So both parties would go to the court with their agreement and the court would make it into an order for them. So they have a bit more security that way.
And just to reiterate to our viewers that if you do opt for that option and you have a consent order, a year after that consent order is made, you can still potentially go back to the CSA stroke CMAC and obtain a further assessment. So it's very important, really. I mean, would you be saying to clients or potential clients, our viewers, that on this issue they should speak to a solicitor, seek independent legal advice?
Yeah, and of course. I mean, it's always better to have help with these kind of options and see what's best for you. Talk it out with your partner, go and seek professional legal advice and have some help.
I mean, certainly in our experience, and more so actually in the last sort of few years, you're finding that couples are talking more and they're trying to resolve their disputes outside of the court process, outside of going to formal organisations. And we often find that that approach is better for these families because particularly when children are involved, it's so much easier for them to get on in the future if they've come to an agreement that they're both happy with. The worst thing that there can be is to have an agreement that's imposed on them and it just continues to cause friction, really. Would you agree?
Yeah, of course, yeah.
So really, moral of the story for us is, make sure you get advice. We're here, to help. Make sure you get advice from a solicitor who deals with family law work. So Katie, thank you so much for joining us in the studio.
Thank you very much for having me.
Thank you. And if you would like any advice on on this topic or any of the other topics that we've discussed, please do not hesitate to contact myself, Katie, or any other one of my colleagues at the International Family Law Group. We are here to help. Our telephone number is 0203 178 5668. Alternatively, please take a look at our website, www.iflg.co.uk. Thank you so much for tuning in, and we look forward to welcoming you again next week. Galinich tasas.